Quite often people are injured on the job, and that creates a whole new set of rules at law that we have to comply with. In essence, a whole new system. Rob, you're a work comp specialist.
That's true. Now, in the work comp system, it's a no-fault system, so regardless of who's at fault in causing the injury, you're automatically entitled to workers' compensation benefits so long as you are injured on the job.
All right, let's say I am injured on the job. What should I do when I discover my injury? And I say that because there's times when I don't discover it right away.
That's correct. Now, once you discover your injury, you should notify your employer immediately. Now, best case scenario is you notify your employer in writing within 4 days. However, you do not have to do that. There's a minor penalty if you don't notify your employer in writing within 4 days. Now, if you don't do that, you can still notify your employer at a later date and still be entitled to workers' compensation benefits. And there's a wide variety of benefits. Now, I've had a lot of clients call and say, look, I didn't notify my employer in writing in 4 days. I heard that I am no longer entitled to benefits. Is this true? No, it's not. On average, you have a 2-year statute of limitations to file a claim for workers' compensation benefits.
Well, let's say, Rob, I'm lifting something heavy on the job. My back hurts. I think it's going to go away. I have a nagging back injury or back pain, not injury, back pain, for about a week or two, and then I go into the employer. Am I going to be subject to these penalties? How do we determine when I have my injury?
Basically, you try to narrow it down to what was the main cause, the substantial causative factor of your injury. Now, when you notify your employer, that is the best case scenario, to sit down with your employer and try to determine when in fact you did sustain the injury, and then you can contact a health care provider, or your employer can send you to one, and you guys can try to diagnose the problem in the situation and when the injury may have actually occurred.
What's my employer supposed to do when I report a back injury? Now, or any kind of injury? Ideally,
your employer should give you a list of healthcare providers that you can choose from, or just direct you to a particular healthcare provider for you to receive medical care and treatment. And within 10 days, they should notify their insurance carrier.
Who's going to pay for this healthcare provider?
Your employer is 100% responsible for all payments to the healthcare provider. You should not make any co-payments. You should not have to pay for any prescription medication, and you should get reimbursed for any mileage.
Well, what if my employer refuses to file a claim, saying you weren't really hurt or I don't have any insurance?
At that point in time, you might want to consult an attorney, or you can contact the Division of Workers' Compensation and get what's called an application for hearing, in which case you will be applying for a hearing for an administrative law judge to make a determination on whether or not you're entitled to receive workers' compensation benefits, and whether or not you can prove by a preponderance of the evidence if you were injured on the job.
Well, during this time, though, when the employer won't file the claim, won't notify anybody, won't send me to the doctors, if I need medical care, can I go to my own doctor?
Yes, you can. You can go to your own doctor, and what takes place then is there's almost a shifting where the employer is no longer in control of the health care, and you get to choose which doctors you want to treat with. And the employer eventually, if you win at the hearing, will be responsible for the payment of any medical care and treatment you receive as a result of the work-related injury.
So the employer is still going to have to pay for my doctor?
Yes. If they find that your claim is compensable, which means if the judge determines that you are injured on the job, then your employer will have to pay for all medical care and treatment associated with your work-related injury.
If I've already paid for the doctor, do I get reimbursed?
Yes. You can make a claim to get reimbursed, but you have to put the work comp carrier and your employer on notice that you're seeking medical care because they have specifically denied all treatment.
What if my doctor's not certified or has all those fancy classifications you need for the work comp division?
Now, it's helpful if your doctor is what's called level 2 certified, and that's a work comp certification, but it is it's not mandatory until you get a permanent impairment rating, and that's something we can deal with down the road. But initially, absolutely not. It's not mandatory. I have a lot of clients where their employer will deny medical care and treatment, and they will start treating with a chiropractor. The chiropractor will work on a lien so the client doesn't have to pay for anything until we go to hearing, and then we have the chiropractor testify that his or her findings are consistent with a work-related injury.
How do I find out if my doctor is level 2 certified?
A simple phone call, and also there's a list on the Division of Workers' Compensation's website of all the level 2 certified healthcare providers in the state.
What should I do if my employer denies my claim after I've been to the doctor?
Same situation. Consult an attorney. If that would be my primary recommendation, would be to consult an attorney, because a consultation is free. You have nothing to lose, and you can make a decision at that point in time whether or not you want to meet with another attorney, or in turn you think you can handle this on your own, then you can do that. But what needs to take place is an application for hearing needs to be filed, and you need to find out what's the specific basis of the reason your employer is denying the claim.
Is my workers' compensation claim handled on an hourly rate, a fixed rate, a contingency rate?
It can be handled on an hourly rate. However, by statute, the work comp attorney is not entitled to charge more than 20% of your benefits, and that doesn't include past medical benefits. It includes indemnity benefits, which are permanent disability benefits or wage loss benefits, things of that nature.
So if I'm hiring the lawyer on a contingency basis, the contract should not state anything more than 20%.
That's correct. It's mandated by Colorado statute.